Officer Dave, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mr. Bay.
Hello, Judge. Your Honor, I'm on Midland versus Soda, but I've got another hearing that I'm doing. I have no objection to defense counsel motion to withdraw.
All right, can you give me two calendar minutes right now?
Okay.
All right, let's do it now because I have her here. We're on the record. This is 22-183670 Midland Credit Management versus Delilah Soto. Your respective appearances.
J. Baig, BAIG, P36820, appearing on behalf of plaintiff and the attorney of record.
And good morning, Candace Arroyo, P83225, appearing on behalf of myself and Delia Soto.
Mr. Baig, I understand you have no objection to the motion to withdraw.
I have no objection. I'd like to sign off so I can handle this other hearing.
Okay, I'm going to give you the next date. You're good free to go. October 20 at 10 o'clock. I'll send out an order.
Thank you.
All right, you're free to go, Mr. Baig. Thank you. Counsel, this is your motion to withdraw.
Yes, Your Honor.
Have you received any pleadings or response from your client in response to your motion to withdraw?
I have not, Your Honor.
All right, this matter was last before the court on September 13th. And on that date, the court sent both to counsel for both sides as well as to the individual defendant the notice of today's motion to withdraw as counsel. The matter is calendared for 10 o'clock. And you indicate that you have not had a response from your client.
Correct.
Please proceed with your motion.
Your Honor, it is our understanding that Ms. Soto has gone missing in action. We've contacted her. We've had letters sent to her in Spanish as well as English to get in contact with me, and she's had no response.
And that's caused a breakdown in your relationship?
Yes, Your Honor. I can't
represent somebody who won't communicate with you.
Correct.
Kind of hard to do that.
Yes.
I've been in your shoes. All right, here's the situation. The defendant has failed to appear. The defendant was given actual notice of today's hearing. As you will recall, I declined to hear the motion the last time we were here because I want to make sure that she had been given an opportunity to be aware. I am going to grant your motion to withdraw. I am going to set this matter for pretrial October 20th at 10 o'clock. We will send you a copy of the order permitting your withdrawal. We will send to Mr. Baig and to your client directly notice of the pretrial for October 20th at 10 o'clock.
Thank you, Your Honor.
Good luck, counsel. Thanks for coming in.
Thank you.
Okay, we're off the record.
Good morning.
Good morning.
Your Honor.
We are on the record. This is file number 22-187674. Richard Oswald versus Progressive Michigan Insurance. Could I have your appearances, gentlemen?
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff, Mr. Oswald.
Charles Blakey, Your Honor, on behalf of defendant Progressive P77261.
When we were last together on August 25th, the defendant had failed to make the 2.3028 disclosures. Have they been made?
Yes, Your Honor.
Okay. That resolves one easy thing. Now, Mr. Clardy, what is your claim about?
It is a PIP case, Your Honor.
Figure that part out.
Yep, that's pretty straightforward, isn't it? We have unpaid medical, Your Honor. That totals at least $17,110. I'm looking at the rest of this. I do not see any lost wage. So there's no wage loss claim. There is no household services claim as of today's date. And there is no attendant care claim as of today's date.
Is there ongoing medical treatment?
Look at that. I do not. Well, hang on a moment. I don't want to misspeak, Your Honor. Hang on one moment. Let me check. Your Honor, my client has gotten, it looks like has gotten treatment within the last year. But I do not think he is presently treating. But that's, I mean, I guess that's, I guess the best way to answer this is that he may be getting additional treatment in the future.
Okay, well,
but
then we have an obvious problem. You know, we're getting close to my number. So let's do this. Let's have you get a harder line on that one way or the other. Is still treating, is not still treating. Let's get you guys another date and get you out of here. Does the October 20 at 10 o'clock, does that work for both of you?
that works for plaintiff, Your Honor.
Mr. Borky?
Calendar, Your Honor. Your Honor, while this is ongoing, can we have discovery opened? My clients informed me that the plaintiff is still treating. Plaintiff attorney has provided me a demand. I have gotten some authority on this file, so I was going to respond to plaintiff's demand today. But that discovery would allow me at least to figure out with additional medical claims, because as part of plaintiff's demand, there's a lot of medical providers that simply say unknown. So that kind of scares me, as you mentioned, with the threshold limit.
Okay, well, let's do this. Let's get you guys that October date. And by way of discovery, what are you asking? I mean, the whole point of the disclosures is to get you most of, if not all, the information you need to evaluate your file. That's the whole point of doing it.
Oh, I agree. There was an IME that was set pre-litigation that plaintiff failed to attend. That was rescheduled. Plaintiff attended it, didn't fill out any forms, therefore it was effectively canceled. That would basically be getting rescheduled as well. I'd like a deposition of plaintiff in this case due to his ongoing claims.
You know,
Your Honor, can I respond to that before?
Yes, you can.
So Mr. Boyke, my client did try to attend an IME. He's under no obligation to fill out forms whatsoever. All he has to do is show up. There is no case law. There is nothing in Michigan law that requires him to fill out any forms. So he tried to show up. Your doctor used profane language, kicked him out of his office.
Okay.
And you're saying that it was effectively canceled.
Okay, so you guys ain't dating. Okay, I figured that out. This is what we're going to do. Since we can't seem to make nice. October 20th at 10 o'clock, we will return. On that date, you gentlemen will have for me an agreed upon deposition date for the plaintiff, Richard Oswald. That deposition will take no more than 2 hours. And so you guys can work out when and where. But I expect to have that ready to go. I don't expect you to get it done because I know it's hard to schedule things. But I expect to have a judge, we're going to depose the plaintiff at this date and time. Got it?
Understood, Your Honor.
Okay, because if your guy is still treating Mr. Clardy, I'm real fuzzy. When I get, because what usually happens is I get from $17,000 claim, next thing I know, I'm at $30,000. And I've been messing in a case that quite frankly, I should not have been involved in at all.
Yes, Your Honor. I will do I'll do more of my homework and make
Okay.
sure.
October 10th at 10 o'clock. And Mr. Boyke may take the deposition of the plaintiff, that deposition to be no longer than 2 hours. And when I see you gentlemen on October the 10th, you will be able to tell me the date and time and place for that deposition. Is there anything else we can accomplish today?
I don't believe so, Your Honor.
Mr. Boyke?
No, Your Honor. Thank you.
Okay, let's be safe, gentlemen. Mr.
Thank
Clardy,
you.
I don't know if I have your other side as of yet. I'll have to check and see. I have 2 people whose names don't seem to match my list today. Mr. Boyke, I'm going to release you. I have another matter with Mr. Clardy.
Thank you, Your Honor.
Thank you, sir. Put you back in the waiting room and we'll figure out what's going on here.
Yes, Your Honor. I do have another matter with Judge Adams this morning as well at 10 o'clock. It's my understanding she's covering Judge Coleman's docket as.
No, it's the other way around. Judge Adams has left.
Oh, thank you. That's right. That's
Coleman
correct.
is covering her docket this week.
Okay. All right. Well, I got to go over to Judge Coleman's.
Pop over there and see what's, and I'll get back to you.
Okay. Thank you, Your Honor.
Okay. All right, put you in the waiting room. All right. Hello? What is your name? Hello?
Hello, Your Honor.
What's your name, sir?
Rory Coleman.
Mr. Coleman, why are you here? Oh, are you here with Beaumont Hospital?
Yes, sir.
Okay, I think I have the other side. That's 474. Let's get started. Morning, Counsel.
Good morning, Your Honor. How are you?
Good. How about yourself?
Good.
This is file number 21185-474. William Beaumont Hospital versus Torrey Coleman. Date and time for pretrial. Your appearances.
Good morning, Joe Sapersky, P63844 on behalf of William Beaumont Hospital.
And what is your name, sir?
Rory Coleman, Your Honor.
All right. This is our second pretrial. Where are we on this file, gentlemen?
Your Honor, I believe this is the first time I want to say that I was ill on the 25th of August, so the court thankfully rescheduled. That's kind of my recollection of the matter. Based on Mr. Coleman's answer, somewhat of a general denial, I did forward him the complete itemizations of the services, which I do not attach to the plaintiff's original complaint as they have protected health information. So hopefully Mr. Coleman has received those and been able to look at those and understand what plaintiff's complaint is.
Did you get that information, Mr. Coleman?
I did, Your Honor. I did see the services, and I saw that it was a series of co-pays and from services in the past that needed to be paid.
Okay. Then what I'm going to do is I'm going to give you gentlemen a return date. That date is going to be October 20th at 10 o'clock. And I'll continue your written discovery. In the meantime, I'd urge you to move forward on resolution on the file. Is there anything else? Is there anything else we've accomplished today?
I don't believe so, Judge.
Mr. Coleman?
Oh, Your Honor, that sounds good.
Okay. Thank you, gentlemen. October 20th at 10 o'clock will be our next pretrial. Your written discovery remains open. Thank you for coming in. We're going to let you go now.
Thank you. Have a good day, everyone.
All right, let's be safe out there.
Bye-bye.
Morning, Counsel.
Good morning.
I had Mr. Clardy earlier. He has another matter that he's on in another court in my building. So just want to let you know I knew you were there. As soon as he gets back, we'll get started on your file.
Okay, sounds good.
We just heard Valerie Chime talking about FCC shutting down. Listening to the Halifax edition of Tempo today, you're listening to some music. And then doing this rap. Well, here's a whole symphony meant to fill you with anticipation. Now we're about to hear music by Joachim Warth, who was a Swiss German composer in the 1800s. Joachim Warth's Symphony No. 10 is nicknamed. So it's basically a love letter to the season. The first movement is called Impressions and Feelings, and it offers poetic musical musings on the stunning display of colors. The second movement is the ghostly roundness. So the arrival of 7 ghosts is announced in the double bases. The third movement is the elegy, which is so beautiful, with warm strings and long musical lines for days. And the end. So here it is, Joachim Ross to autumn time.
All right, we are on the record 22-187-988. Latvidia Hereford versus the Liberty Surplus Insurance Company. Your appearances.
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff.
And good morning, Haley Messenger, P82953, on behalf of defendant Liberty Surplus.
Okay. We made our 2.3028 disclosures. Where are we on this file?
We are currently getting dates to schedule the deposition of plaintiff and her service provider for replacement services. I believe we've been in contact with plaintiff counsel's office and we're agreeing on dates this week. So we were looking for an adjournment of maybe 45 to 60 days to complete these depositions, and we should be able to wrap this one up.
Mr.
Your
Clardy?
Honor, I'm sorry, Your Honor.
I'm sorry, where are you going? Where are you?
I was going to ask Your Honor if the court has issued a scheduling order as to depositions, because I'm not aware of any going out from you.
I have not. At this point, the only thing the court ordered was the 2.3028 disclosures. And as you know, discovery in the district court is by one of two ways. It's by stipulation of the parties or by order of the court. I think that's the guy in the row. I think that's me. I have not issued any orders in that regard. So I guess you guys have stipulations in regard to that. Is that where we are?
We have not agreed to a deposition, Your Honor.
Counsel, what's going on?
I spoke to the handling attorney on this file. She told me that she was reaching out to plaintiff counsel's office for deposition dates. So there may be some disconnect. Therefore,
There
we
apparently
will need to
is.
file a motion to
First of all-
request depositions.
First of all, let's find out whether you can do it by stipulation or not.
Okay.
Apparently has some failures to communicate. What I'll do is I'll give you a return date of October 10th at 10 o'clock. I know that works for Mr. Clardy because I have another matter with him at that time. What are we, because if you got replacement services, I take it you have an ongoing claim here, Mr. Clardy?
No, Your Honor, I don't believe it's ongoing. I believe that's pretty set in stone. The only thing that we're really looking at is to see if there are any liens being asserted by two health insurance companies. We did do a lien request through MDHHS. They returned a zero balance, but they did indicate that there were these two health insurers which may assert a lien. So we're trying to get to the bottom of that, and then we should be able to make a full demand to defense.
All right, so let's do this. We'll see you then October 20th at 10 o'clock. Let's follow up on those outstanding lien or not lien so we can have some idea. Is there something that is still ongoing, or are we in a position now we can kill the file? If you can't kill the file, then you can't work out by stipulation, then I'll need your motion, counsel, in regard to the depositions. But again, the whole purpose of the 2.3028 disclosures is to get you guys information that you need to kill the file without further running the mill. That's the whole concept here. And I really wish when they did the rules, I wish they had made 2.3028 disclosures mandatory to district court, because I think that would make our life a lot simpler, but that's not. I'm not on the rules committee, so be it. We'll talk to you again, October 20th, 10 o'clock. Thanks for coming in.
All right. Thank you.
Thank you, Your Honor. Stay safe, sir.
All right, let's be safe out there. Show up. You know, do that. She would have computer on her document.
Still sunshine and Kimchi and brightness. We just heard music by Joachim Rapp, the symphony number 10 called The Autumn Time. If you are working on autumn theme music or you're in a tempo today, then you're invited to visit cbc.ca/listen. Click on my radio, look for tempo, and click on today's date to see all of today's
That's something to do about
cbc.ca/listen. More about presentation coming your way in a few short minutes. Right after this spread. So what this hour? I'm Joe Cummings. The protests continue in Russia in the wake of the Kremlin calling up 300,000 reservists to bolster the Russian war effort in Ukraine. Many protests overnight, that's specifically in Moscow. At the same time, international analysts continue to evaluate another decree from the Kremlin this week. It's Vladimir Putin's threat to use nuclear weapons in the name of protecting Russian territory. Murray Brewster explains. Donald Perel is chair of Ukrainian studies at the University of Iowa, and says the Russian president's nuclear threats have not stopped NATO from arming Ukraine. Russia is proposing to hold referendums in 4 territories it occupies in Ukraine. Of the Kremlin leaders once annexed, those parts of Ukraine fall under Russia's nuclear umbrella. We won't hesitate to use them. Which Ukrainian forces territory, its expert Christian Lukov says it's now a no for Russia. If they don't go as far as the next 10 days or so, there will be a referendum for them to hold. At the same time, the country's parliament should push its resolution and the law introduced Tuesday. This is voluntary surrender of soldiers. CBC News. Now to Atlantic Canada. Expecting obviously a major event currently. That is Erica Fleck with Halifax Regional Fire and Emergency. The major event he's speaking of is Hurricane Fiona. Expected to hit the east coast of Nova Scotia tomorrow night. With Fleck particularly concerned about flooding. We had quite backdrop conditions throughout the summer. It's very dry. So now rainfall is going to cause a lot of localized flooding. We can expect no large-scale power outages. Fiona is expected to be downgraded to a post-tropical storm plan in Atlantic Canada, but potentially dangerous winds, torrential rain, and storm surges are expected this week and right across most of Nova Scotia, eastern Quebec, and western New England. The David Trudeau government finally makes good on its promise to formally review the Cannabis Act. It comes nearly 4 years after the proposed marijuana. Yes, McGregor reports. Well, I'm very skeptical to legalizing marijuana. I appealed to a lot of voters back in 2015, but the legislation required that the health minister had to review the effects of cannabis legalization, in particular the effects on young people, on indigenous communities, and how allowing cultivation in private homes is working out too. You know, the potential economic benefits for legalization in the first place.
That's amazing. Gentlemen,
Good morning, Judge.
this is 20165-999. New Horizon Chiropractic versus City of Detroit. Matter comes to me by way of a remand with just a decision of the Circuit Court. Appearances.
Good morning, Daniel Groves on behalf of the plaintiff, New Horizon Chiropractic, P number 74026.
Good morning, Judge. John Cahalan, P77404 on behalf of defendant City of Detroit.
I see that in the Circuit Court, City of Detroit did not file a brief or appear oral argument. Where are we on this file, gentlemen?
Yeah, this defense counsel told me that this is not the same defense counsel here today that was at the prior one. And defense counsel Teresa Oled had made a statement that she didn't agree. So she was not going to file a brief or make an appearance because that way she would know that it would move forward. So that's what happened, Your Honor.
So where are we on the file?
Well, it's been remanded, so I'm looking for a scheduling order to continue now with new counsel for the City of Detroit. I'm not sure what new counsel will request of this court, but of course I leave it to the court's discretion, but it's been remanded. So either we pick up where we left off, Your Honor, or there's a new scheduling order that has to be issued for discovery, depending on what brother counsel asks of this courtroom.
Counsel?
Judge, I would be amendable to whatever the court would like us to do here. If the court would like to issue a new scheduling order, get a little bit of discovery in, see if we can work this one out. That would be, I think, what we would like. But obviously, the court is your court, Judge. So whatever the court would like to do here.
Well, I have a problem here. In my brief review of the file, it appears that I dismissed the matter on July 27th of 21 when the plaintiff failed to appear for a pretrial conference. Then afterwards, there appears to be an order that was entered on August 6th for partial summary disposition. So that's obviously problematic. Can't issue an order in the case after the case has been dismissed. So I think the first thing that needs to be done by way of housekeeping is we need to decide what's going to be done with that August 26th order, which is an order granting partial summary disposition for the City of Detroit.
Which was my point exactly, that order was issued after the court had already spoken. The court speaks through its orders. So I would agree today that order does not stand, nor should it stand, and that if brother counsel wants discovery and we move forward, but well, I in my brief in both courts, I made that very point. That order cannot stand. So I concur now today with the court that it should not stand.
it should not have been entered because apparently it came up to me after, but that's neither here nor there. That's a mechanical problem. The court granted the motion for partial summary disposition after argument. And I think what we need to do is I'm going to give you gentlemen a return date, and the city can decide whether they're going to seek to defend that order or not. Because obviously I didn't just enter an order for partial summary disposition out of the sky.
No, but let it be noted, please, Judge, that it was an administrative error on the court's part that had that order subsequently. The first dismissal was again an administrative error on the court's part, not plaintiffs. So I understand what the judge is saying. I understand what you're saying. And if this court wants to offer brother counsel the opportunity to argue an order that should have never been entered based on a dismissal that shouldn't have never been entered due to administrative error, that's the court's discretion. I understand, but I believe it's all moot. I think plaintiff is respectfully suggesting a scheduling order as far as discovery be issued, and we move as if this is just a continuation, short period for City of Detroit to have discovery, and hopefully we can resolve this.
Well, what I'm going to do is I'm going to give you guys a return date of October the 20th at 11 o'clock. Does that date work, the time work for everyone?
It works for plaintiff.
All right. Mr. Callahan?
Yes, that works for me, Judge.
By that time, I expect something in writing from the city court on that all order,
Okay,
because clearly what happened here is I made my decision. Then we had the pretrial, and the lag time was such that the file was separated from the order. But obviously I cannot enter a valid order after the case has been dismissed. So if it is your intention to defend that order, I want something in writing. If it is your intention to abandon that order, I want something in writing.
okay.
Mr. Porter, Mr. Groves, what is the amount of your claim?
The total amount of the claim being sought is $7,995.
Okay. All right,
Okay.
gentlemen, you think, we'll see you October 20th at 11 o'clock.
Okay, understood.
At that point in
Thank you,
time,
Judge.
we have a posture about where we're going on this file.
Absolutely.
Brother counsel, if you could please contact me at Bay Shore Green, I'd appreciate it.
Can you
Absolutely.
guys just hang on? I could drop you into a chat room right now,
Thank you.
Okay.
assuming I can make the technology work. Two.
Thank you, Judge.
All right, counsel. Morning.
Good morning, Judge Robinson. How are you doing?
I'm good. How about yourself?
Oh, I'm doing fine.
I don't have your opponent as of yet, but I just want to let you know I knew you were there. And we'll get back to you, as soon as he comes in, or by 10:30.
Okay, yeah, no problem waiting here. Got good multitasking going on in Zoom as typical.
All right, back to the waiting room.
All right.
All right, we're all set. I don't know if the court wants any further appearance from either party. We talked in the breakout room. We've come up with a plan. We think we're going to be able to adjudicate it quite well.
We'll talk to you in October. Thanks for coming in.
Thank
Have
you.
a good day.
Thank you. I'm pissed anytime I shoot with somebody.
We are on the record calling file number 22-191-030. The file is entitled Midland Credit Management versus Kimberly Bowles. By a notice dated August 25, 2022, this matter is set for pretrial today, September 22nd at 11 o'clock. It's now after 11:30. Could I have your appearance, please?
Yes, good morning, Your Honor. Gavin Gray, P79819 for the plaintiff, Midland Credit Management.
Mr. Gray, good morning. The defendant has failed to appear. No good cause for that failure having been shown. The default of the defendant is hereby entered. We'll send you out an order to date, sir, on that default. Thank you for coming.
Okay. All right, thank you, Your Honor.
Have a
Yep,
great,
have a good afternoon.
you too, sir. We're off the record.